Someone make it make sense.
Probably a couple.
All right, guys, this is insane. So why does it not look like it's full screen? Hold on, let me stop sharing my screen real quick so I can try to make sure this is sharing it correctly. I can't, I don't have words. I thought it was going to be a verdict. And then when she said she had a note from the jury, I was like, huh. And then I was like, what? No way. There's no way. There's just, there we go. There's just no way. Hi, Kitsmits. Happy to see you. I thought I almost threw up. I almost threw up. I literally started like, I'm like shaking and I'm like, I almost, because that is terrifying. That's terrifying. That is so, this is scary. This is terrifying. How? Now, okay, before I freak out too much, or you guys maybe, it could be one of the other charges, like a lesser included. All right, here's what's going on, Kitsmits. Let's watch it and we'll talk about it. All right, here we go. Let's watch. This just happened, just now.
You are unmuted.
Let's watch together in shock and horror.
Thank you. You see the concession.
We're back on the record on 22-117, the Commonwealth versus Karen Reed.
Okay. All right. So, counsel, you're aware of our note from the jury. Dear Judge Cannoni, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict signed by the foreperson. So I want to hear from counsel,
God, I throw up again.
Your view on whether there has been due and thorough deliberation. So let's start with the Commonwealth.
My answer would be no, Your Honor. This simply hasn't been sufficient time yet.
And what does the defense say?
We believe that there has been sufficient.
All right, so I'll hear from both of you in more detail. Mr. Lally, I will hear you.
Okay, so first thing that I will say is interesting. I saw this live as well. First thing that I will say is interesting is that Lally says he doesn't believe there's been sufficient time. And Yanetti says he does believe there has been sufficient time. And this is going to become important when he gets to his argument, but I find it interesting because I wonder if they were not expecting this and they're trying to weigh it out. So basically, how would you argue? Why would you argue one way versus another, right? It's all about, they have to try to calculate the odds, right? It's like, if you're defense counsel, okay, and you're thinking, okay, they're hung, and you're thinking that there's more than one person, right, that thinks Karen Reed is guilty, okay, that there's two or more people say, right, and it's not just one holdout, and it's people that are holding out. Everyone else says not guilty, and two or more people says guilty, right? Then you would be in your benefit to argue they've deliberated enough. It's blah, blah, and then it's declared a mistrial because that would be the best outcome for you. Now, if you think instead that it's maybe everyone's not guilty and there's one holdout that's saying guilty, right? And that the other 11 can convince the one holdout that it should be not guilty. And if you're the defense counsel, then you would say, no, send them back and make them try again, right? This is a big, either way, the instruction is going to be read, but this is kind of a gambling thing here. But what's interesting is that Yanetti initially says they've deliberated long enough, right? So, okay, so let's see what happens next.
Your Honor, the jury received this case just earlier this week. They've had slightly shortened days, and I'm not in any way, shape, or form suggesting that they haven't conducted their due diligence in regard to their deliberative process, but I would submit that it is far, far, far too early in their deliberative process to even consider giving them any kind of Tuey-Rodriguez instruction or anything close to
So
that.
that's the first
Furthermore,
thing that's
with
interesting. Tuey-Rodriguez, that must be specific to Massachusetts because it's in every trial, it's the Allen charge. So I would imagine it's the same thing, but it's just a different name because of Massachusetts. I don't know how to spell it. I'm going to try to see if I can find out what it is, but just you can swap that in your minds for Allen charge. And if anyone isn't sure about an Allen charge, let me know in the chat. But you probably,
the note doesn't really indicate affirmatively that they can't come to a conclusion. It just says that they haven't come to a conclusion through their deliberative process at this time. They're not even asking for one, is what I would say.
All right, thank you. Mr. Yanetti, I'll hear you.
Your Honor, I would disagree with Mr. Lowry's characterization of the note. The word exhaustive is the word I think that's operative here. They're communicating to the court that they've exhausted all.
I found it. It's Tuey-Rodriguez. Okay, I found it. I've got it right here. I can actually pull it up. Okay, let me do this. Okay, I'm gonna pull up the charge. I'm gonna pull it up. I wonder if we will be the first people to be able to show you guys exactly what they're talking about, because this is an unusual one. Let me pull it up. All right, ready, guys? It's loading. All right. This is it. Tuey is Tuey Rodriguez charge. All right, let's take a look at this. When jurors cannot agree. Oh my God, stop it, Adobe. Freaking Adobe. Okay. All right, we're looking at this is what I would say, imagine is comparable to the Allen charge. All right, our Constitution and laws provide that in a criminal case, the principal way for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking in all cases, absolute certainty cannot be attained or expected. That's interesting. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusion of the other jurors. Still, in order to bring 6 minds, 12 minds, to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that the case be decided. That's going to be one main point here, okay? You should consider that, this is yet another one. You should consider that you've been selected in the same manner and from the same source as any future jury would be. The point of that is to be like, no one else is going to do any better than you guys. If you guys can't do it, no one can. That's the point of that. There is no reason to suppose that the case will ever be submitted to 6, 12 persons who are more intelligent, complimenting them, flattery, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced on one side or the other. With all this in mind, it is your duty to decide this case if you can do so conscientiously. So they don't want them to, like, you know, not feel okay with coming to a verdict. Like that, I find it really interesting that this works, because to me, it's like, if they could have done it, wouldn't they have already? But that's just me. But see, I'm also very opinionated, and like, I have a lot of convictions on stuff that I think, and like, you know, it wouldn't be like you could talk me into something. But again, that's not necessarily what should be happening. It's a funny process, right? This whole process of deliberating, because they have to stay true to them, what they believe and their convictions, right? But yet there is a process here. It's fascinating. Super Planner Girl, let us know in the chat if you had any interesting experiences when you were on a jury about this process, if there was anything like that. People, you know, changing their minds and the like. All right. In order to make a decision more attainable, the law always imposes the burden of proof on one side or the other. In this criminal case, the burden of proof is on the Commonwealth to establish every part of it, every essential element beyond a reasonable doubt. If you are left in doubt as to any essential element, the defendant is entitled to the benefit of that doubt and must be acquitted. I feel like this would be good for the defense. What about you guys? Like this, I feel like would empower them to come to a not guilty verdict, in my opinion, so far. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, those jurors who are for acquittal should consider whether a doubt in their own minds is a reasonable one, if it makes no impression on the minds of the other jurors who are equally honest, equally intelligent, and who have heard the same evidence with the same attention and with an equal desire to arrive at the truth, and who have taken the same oath as jurors. On the other hand, those jurors who are for conviction ought seriously to ask themselves whether they may. This is good. This is good. You know, it's asking both sides of the fence, right, to kind of consider. Ought seriously to ask themselves whether they may or may not reasonably doubt the correctness of their judgment if it is not shared by the other members of the jury. They should ask themselves whether they should distrust the weight or adequacy of the evidence if it has failed to convince the minds of their fellow jurors. So it's like saying, well, you know, maybe you believe that you have the right idea here, but like, look at the rest of your jurors, man. If they don't see it that way, you know, I would ask you now to return to your deliberations with these thoughts in mind. And that's the model instruction. And then there's also an alternate instruction here. So I don't know that we need to read the alternate instruction. I'm going to leave this up in case we need to refer back to it. Okay, but now let's go back to this. All right, and I'll see what you guys are saying in the chat. So why can I not play it?
Manner of compromise, all manner of persuasion,
Jim.
and they're at an impasse. You know, this is a case where the jury has
Changes his mind.
instructions. They've only really asked one question, which was to try to get a report that they were not allowed to get. And I think the message has been received that the evidence is closed. They won't get anything more.
Remember, his initial position was they shouldn't be instructed to go back and deliberate further. His initial position was, I think he was thinking, no, they've done all they can. It should just be a mistrial. And so let's see what happens.
They've been working essentially nonstop over the last 3-4 days. We're approaching a weekend. They didn't come back with this at 3 o'clock or 4 o'clock.
I'm
They're
shocked.
at 12 o'clock, and they have nowhere to turn. So our position is the jury should be read the Tuey-Rodriguez model instruction. So
that is different. He says they should be read the model instruction. Now, again, what did I just say? We just went over it. I think that instruction is good for the defense. And if I had to guess, I know everyone's going to speculate. I don't know what anyone else has said because it's just happened. So I'm going to go ahead and speculate with my speculations. I would imagine that what is going on is there's probably one holdout for saying guilty. I would imagine it's 11-1 because this is shocking to me. And this is very rare. Hung juries are very rare, at least if they end up being hung in the long run. Because what will usually happen is after they've been instructed, they'll come back with a verdict, okay? My thought is it's 11 for not guilty and 1 for guilty. That would be my guess. And I would imagine probably all of Law 2 is saying something very similar. But he must have rethought it because initially he was like, no, they've done enough. And I think, again, best case scenario, he was thinking is a mistrial, but he must have thought about it while Ollie was talking and thought, well, hang on, we believe in our case. Maybe him and Jackson confided in each other, chatted. I don't know. But in other words, it's interesting to me that Lawley thinks that if they deliberate further, it's going to come to a conviction. That's shocking to me. Like, it should have been the other way around. He should have been like, no, they can't do it. Because again, if it's a mistrial, they can try the case again. If she gets acquitted, they can't. So Lawley is in backwards world as always. Okay. Yeah.
And go from there.
Okay. All right. So you all know that it is within my discretion. I decide. So a case that has been,
Wow.
It's a long case. This is our 4th day of deliberations, but Tuesday was a short afternoon, maybe 2.5 hours.
And we know they were
Wednesday,
just chatting,
they
probably.
left early because of an appointment. Yesterday was also shortened a little bit, and this note arrived with less than 3 hours of deliberations today. So the length of the trial, the length of the deliberations, I know the case we heard from 74 witnesses. There are 657 exhibits, very complex issues in this case.
Not really.
I'm not prepared to find that there have been
he wasn't hit by
doing
a
thorough
car,
deliberations
so.
at this point. So I am going to send them back out. We'll bring them in and we'll do that now.
So what I'm saying though, the reason I'm saying that Yanetti changed his mind is because he didn't argue. He said that they should be able to go, they should be able to read the instruction. And initially he said, no, they should be done. They're, don't send them back or whatever. Let me just make sure I'll get it. Let me get his verbiage correctly. But he changed his tune there. Initially, he was saying that they deliberated sufficiently, right? That's what he was saying initially, that the deliberations were sufficient. And then
we're approaching a weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is the jury should be read the Tuey-Rodriguez model instruction.
that's
And
different.
we'll go from there.
Okay.
He doesn't say our impression is that they've deliberated all they can do. That's it. Mistrial. He says they should be read the instruction. That the instruction tells them to go deliberate more. That's why I'm saying this is interesting to me. Right, the Allen charge, but initially he says that they had their deliberations were sufficient, as in they can go home. Like that's it. Mistrial, right? Let's listen. Let me go back up. Let's listen again to his initial statement here so we can hear.
This week, they've had slightly shortened days, and I'm not in any way, shape, or form suggesting that they haven't.
Go back further.
Evidence. We have been unable to reach a unanimous verdict signed by the foreperson. So I want to hear from counsel your view on whether there has been due and thorough deliberation. So let's start with the Commonwealth.
My answer would be no, Your Honor. This simply hasn't been sufficient time yet.
And what does the defense say?
We believe that there has been.
There has.
All right, so I'll hear from both of you in more detail.
Does that make sense? He says there has been sufficient. You only ask them to read the charge if you think that there hasn't been sufficient deliberations and that they need to go back and continue. So he says there has been sufficient deliberations. So I think initially he's wanting to go for a mistrial, but he changes his tune I think he thinks about it more. And maybe let me see, I'm gonna play it and see if he talks to Alan Jackson at all.
Mr. Lally, I will hear you.
Because I'm wondering.
Your Honor, the jury received this case just earlier this week. They've had slightly shortened days, and I'm not in any way, shape, or form suggesting that they haven't conducted their due diligence in regard to their deliberative process, but I would submit that it is far, far, far too early in their deliberative process to even consider giving them any kind of Tuey-Rodriguez instruction or anything close to that. Furthermore, what the note doesn't really indicate affirmatively that they can't come to a conclusion. It just says that they haven't come to a conclusion through their deliberative process at this time. So they're not even asking for one, is what I would say.
All right, thank you. Mr. Yanetti, I'll hear you.
Your Honor, I would disagree with Mr. Lowry's characterization of the note. The word exhaustive is the word I think that's operative here. They're communicating to the court that they've exhausted all manner of.
Wait, did they use the word exhausted? Let me go back to the note because that matters. I know. Let me just see.
Process at this time. This week, they've had.
See what the note says verbatim.
We're back on the record on 22-117, the Commonwealth versus Karen Reed.
Okay. All right, so counsel, you're aware of our note from the jury. Dear Judge Cannoni, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence,
All right.
we have been unable to.
So they did use the word exhaustive. So what's interesting is again, initially Lawley says make them go back, right? But he says it's too early for that charge to be read. Let's listen again. I'm going to point it out when we get there again because we'll see.
Unanimous verdict.
Let's listen again.
Signed by the foreperson. So I want to hear from counsel your view on whether there has been due and thorough deliberation. So let's start with the Commonwealth.
My answer would be no, Your Honor. This simply hasn't been sufficient time yet.
And what does the defense say?
We believe that there has been sufficient.
All right, so I'll hear from both of you in more detail. Mr. Lally, I will hear you.
Your Honor, the jury received this case just earlier this week. They've had
what he asks for.
Slightly shortened days, and I'm not in any way, shape, or form suggesting that they haven't conducted their due diligence in regard to their deliberative process, but I would submit that it is far, far, far too early in their deliberative process to even consider giving them any kind of Tuey-Rodriguez instruction or anything
Now
close to
that I find interesting because since we just read it, I think that instruction is good for the defense. He's saying take the least serious approach, right? So in other words, there's two options here. She can either just tell them to go back and keep trying, or she can actually give the instruction, which is what we read. And do they mean the same thing? Basically, yes. But the languaging in that instruction that we read, the Tuey-Rodriguez instruction, I think benefits the defense. So he's saying they've not, this is interesting. He's saying they've not deliberated long enough, but don't read them the instruction. Okay. So let's keep listening.
Furthermore, what the note doesn't really indicate affirmatively that they can't come to a conclusion. It just says that they haven't come to a conclusion through their deliberative process at this time.
Well, they
so
said exhaustive.
They're not even asking for one, is what I would say.
All right, thank you. Mr. Yanetti, I'll hear you.
Your Honor, I would disagree with Mr. Lowry's characterization of the note. The word exhaustive is.
Remember, his initial position was they can't deliberate anymore. They've done their job. Mistrial.
Exhausted all manner of compromise.
I like that he referenced back to their note.
Persuasion,
Jim.
and they're at an impasse. This is a case where the jury has the legal instructions. They've only really asked one question, which was to try to get a report that they were not allowed to get.
Right.
And I think the message has been received. That the evidence is closed.
I have another thought, guys.
They've been working essentially nonstop over the last 3-4 days.
I have another thought.
We're approaching a weekend.
Okay. I'll let him
They
finish.
didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is the jury should be read the Tuey-Rodriguez model instruction and
Model instruction,
Okay.
right? That's the one that we just read. I agree. So he wants her to read the instruction. Let me say this though. Here's what I think happened. I think that Yanetti, as he was listening to Lolly talk and as he started talking, he was remembering about that one question because he says they've only asked one question about the SERT report. Okay, here's the thing about that. That gave the appearance that, okay, this is my gut feeling on this. That there's the one that they knew from, what was that, 2 days ago? Or yeah, that wasn't yesterday, that's the day before. That there was already, they knew there was one holdout. Like, okay, it's possible that they were all not guilty pretty quickly and there was one holdout. And that the reason they were asking for that SERT report 2 days ago was because they were trying to find something to convince the one guilty verdict, okay? And maybe that's what they've still been trying to do this whole time. And then they were like, we've done everything we can. And that's what's happening. That's my thought. Right. He thinks they can come to a decision. But it's just his initial stance was that Lolly said they have not deliberated long enough. And his initial position was they had deliberated long enough. Right. That to me says, unless that's languaging used as in you should read them the instruction. But to me, that sounds like don't send them back. But I don't know. That's just what it sounds like to me when he says because if you give them the instruction or if you just tell them to go back, either way, the result of that means they're going to deliberate more. And if you think they've deliberated enough, I don't know. That's just what makes sense to me. But so Fender says, my question is, why would he say yes if he's asking for the instructions? Right. Because what she's going to do is she's not going to actually read the Tuey-Rodriguez instruction. Remember, that instruction I think is better for the defense. She's going to just say, she's going to give like just what's the right way to put it? Like a paraphrased version of that. And then I would imagine if they come back again, then she will actually read the official instruction. And the benefit, okay, right. Here we go. This is why. Because we were all thinking not guilty, right? Okay. If you find out that they are saying they can't come to a verdict, and if you're thinking that if they continue to deliberate, it would come back guilty, here's the benefit of a hung jury. A hung jury is a mistrial, Fender, okay? So if there's a mistrial, all of it goes away. The charges are gone. She's a free person to live her life as if basically none of this ever happened. I mean, obviously it's not going to be the same. But if there's a hung jury and they give them the charge and they cannot come to a verdict, it is a mistrial. Done. She's that, and after that, it is the Commonwealth's choice if they want to bring charges again. However, it's starting over at square one, ground zero, where they have to go and get a grand jury and get the indictments all over again from scratch. They have to start from scratch and bring charges again. And in this, right, she walks out. In this case, I think the odds of that, because the Commonwealth shouldn't have brought it to begin with, as we know. If the Commonwealth is reading the room and listening to, like, they assess it, they should realize they should not bring it again. And she's free. She's a free person, right? It's honestly, in some ways, it's better than an acquittal because the charges go away. It's not even on her record. It's just gone. They can retry, but I don't think they would. I don't think they would. They would have to be insane. They would have to be insane. And I mean, but still, that's better than a guilty verdict, right? That's why I'm saying that's why it's a gamble. If you're the defense team and you're weighing it out and you're thinking that it's 1 holdout for not guilty and 11 for guilty, and you know that if they go back and convince the one not guilty, it's going to be a guilty verdict, you would rather go for a mistrial, right? And then have another shot at it because that's better than a guilty verdict. So they were insane to bring it the first time, definitely, 100%. So does that make sense though? Like, that's why I'm saying, that's why I think it's a gamble. I think that's why initially he was like going for the mistrial, right? But then he remembered the thing about the SERT report. This is my opinion of it. Like, then he remembered the question about the SERT report and he's like, you know what? Let's trust what we thought. And I agree. My guess here, if I had to speculate, is that it's 11-1, not guilty to guilty. And there's that one holdout. And that's why they were asking for the SERT report, which would prove that there were not those pieces of taillight initially, right? And then that was 2 days ago. And now they're like, we can't convince the one holdout, blah, blah, right? I think it would be a lot harder to start over. I really do. Yep, absolutely, Kit Smits. I agree. So in other words, if you're the defense team and you're thinking if they go back and deliberate further, they're going to come back guilty, then mistrial is your way to go. But if you think about it and you're like, you know what, it's probably the other way around. I bet there's one holdout and the rest are not guilty. Then you would change your mind and you'd be like, no, let them go deliberate further and convince the one holdout. But that Tuey-Rodriguez instruction is really good for the defense. So, I mean, and the thing is there's so many appellate issues. It's not even funny. But that appellate process takes forever, and she would have to be held in custody. Might mean more than likely. I mean, I can't imagine. I don't know how they would do it with sentencing. That's the only thing, right? Like, because as we know, in some places they sentence immediately after. If there's a delay between the verdict and sentencing, which some places have, they could probably get her to remain out of custody until the sentencing, right? So, okay, let's hear what happens next.
All right. So you all know that it is within my discretion. I decide. So
Right.
A case that has been, it's a long case. This is our 4th day of deliberations, but Tuesday was a short afternoon, maybe 2.5 hours. Wednesday, they left early.
And it's on her record.
Because of an appointment.
Yeah, exactly. Kit Smith.
Yesterday was...
Mistrial goes away completely. Never
also
happened.
Shortened a little bit. And this note arrived with less than 3 hours of deliberations today. So the length of the trial, the length of the deliberations, I know the case we heard from 74 witnesses. There are 657 exhibits, very complex issues in this case. I'm not prepared to find that there have been due and thorough deliberations at this point. So I'm going to send them back out. We'll bring them in and we'll do that now.
Okay, so I'm wondering if the charge is only read as a last resort. I'm wondering if that's what that is. So she's saying, I don't think there's been due and thorough deliberations. My guess is you read them that charge as a last resort when you've actually already done what she's about to do, which is say, hey guys, try again. Having said that, I have seen trials. I can't remember which one it was. I've seen more than one though, where they came back and said they were hung and they were like, they didn't send them back. They were like, they just like asked them when they came in, and they're like, yeah, we can't. And they're like, all right. But then I've seen ones where they send them back multiple times. And I'm wondering if you want to save that Tuey-Rodriguez instruction for the last time, like if they've already come back another time. So let's see. So she's not going to read the charge. She's going to do the least, in what's the right word, proactive measure. Like she's just going to tell them, go back and try harder, basically. Wait, what was coming up about Depp v. Heard? Hold on. Let's see. I saw something about Depp v. Heard.
All rise to the court, please. Jurors entering.
All right. So let's see. So she's not going to read the actual charge. My guess is she's going to, if they come back again after this, then she would read the charge, potentially. Okay. But like I said, I've seen it where they did it on the third time. I've seen that. So it could be that they come back again, she says the same thing, and then if they come back the third time, then she reads it. The charge, I think, might be like the last resort. And then after that, if they still come back hung, you're like mistrial.
Right. So, jurors, I'm in receipt of your note. I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a
Fair
unanimous verdict signed by your foreperson. We all know how hard you've been working.
See, this
Lunch will be arriving shortly. When it comes, I'd ask you to clear your heads, have lunch, and begin your deliberations again. So, or continue your deliberations. All right. So I'm sending you back out.
now the difference here,
All rise to the court,
big
please.
difference, guys, is that the languaging in that Tuey-Rodriguez charge, in my opinion, would benefit the defense. So she just said, go have lunch, clear your minds, and then try again. That is very different than if she had read that Tuey-Rodriguez charge that really asks, I mean, fucking hell. And that would explain why Yanetti maybe changed his position a little bit and was like, read them the charge. Does anybody want to see the charge, the Tuey-Rodriguez charge again, or are y'all good? Because she's not asking anyone to reconsider their opinions or really do this or that. She's just saying, have lunch, clear your minds, and just try again to see what happens. My guess is they're probably going to, fucking hell. Okay. I think that there's probably one staunch holdout for guilty. Okay. That's my guess because of the question about the SERT report. And I wonder if what's going to happen is they're going to come back again after lunch and say the same thing. And then she's going to read them that charge. And then my guess is if that happens by the end of the day, that's it. Like they're either going to come, I mean, potentially, right? Maybe they're either going to come back and say, we can't do it and it's a mistrial, or they're going to come back with a verdict. Okay. All right. And you know what? It's a good time for lunch for you, Super Planner Girl, because the jury's also having their lunch. So, and she's basically told them don't deliberate through lunch, which sucks, right? She's like, clear your mind. So have a good lunch. So this is really, I'm shocked. I'm shocked. So, okay. I don't even know, man. This is insane. So that's it. So then they leave. Is that it? Like basically. Yeah. So let's see. Did anything else happen? Probably not, but just in case. So it sounds like they're actually having lunch early though, right? Because they have lunch at this point. So they're going to bring them lunch early maybe. So that was like 48 minutes ago. So if we go live. So, I mean, are they almost done with their lunch? I'm just like, come on, people. So, all right. But here's the plan though. Okay. I mean, as I've said, like y'all see, like it's hard to get a stream up and running immediately when the fan jiggles, right? But like I just listened to, and plus I wanted to see what it was, right? If it was just like a whatever thing. So, but like I'll do the same thing. If the next time that there's some if the next time there's some signs of life, we'll know it's something else substantial, right? Either they got a verdict or they can't. So I will be on the lookout for that fan jiggling, and I will try to go live immediately when that happens, as soon as I can. And so be on the lookout for that. And I still have the stream ready for the verdict if that happens. I think I added a question mark at this juncture. I don't know. I would be kind of surprised though if they come back again. She's like, oh, let's just give them the weekend and have them come back on Monday. I mean, it could happen, but I feel like I don't know. We'll see. I mean, I guess it just depends, right? Like if they come back again, but they don't come back until the end of the day today, let's say. Let me put it this way. If they come back at like 3 o'clock today or 3:30 today and say, we still can't come to a verdict, I could see Bev saying, okay, let's read the freaking official charge and have them come back on Monday. But if they have their lunch and let's say at 2 o'clock or whatever, immediately after lunch, they come back and they say, we still can't do it, I think it could be a different outcome, because then she might read the charge then. And then if they go back and then they come back after an hour, maybe it's a bloodbath in there, we don't know. And they're like, we still can't do it. That might be a mistrial. So we might have, it's interesting, right? They should not, there's no way they know what a mistrial is unless they had that prior knowledge. And I don't know if that's a question that would have been asked of them beforehand. I've heard rumors that there's one attorney there on the panel, on the jury panel. I don't know if this means they're a deliberating juror or an alternate, and I don't even know if it's true. I've just heard people say it, so that doesn't actually like mean anything. It's unusual for attorneys to be picked for juries, and usually if they are, they do something completely different, like a tax attorney or like probate law, or they're like paperwork and shit, right? But someone who's like a trial attorney, like, nah, they're very unlikely, right? So yeah, I don't know. It's just, that seems kind of crazy, right? But, you know, I would imagine that if you're any type of lawyer, you probably know what a mistrial is, but maybe not. If you're someone who just does, you know, contract law for documents and paper, and, you know, you've never been to you've never been a trial attorney, maybe they don't know what it means, you know? But normally if there's no lawyers, right, let's just say that it's a normal circumstance, or that there are lawyers, but lawyers don't know mistrials. They just know they're supposed to try to get a verdict, right? That's it. And so they may not even know the term hung jury, although maybe they would, because it's in like movies and shit. But like, that's why to me, it's like they would only send a message like this if they're like, yeah, we did our best and we can't do it, right? So now if the okay, well, yeah, no, I was thinking way too much into it. Like if the people that are not guilties are like, no, that mistrial is the best case for Karen. So they're like, let's do it. But that's none of that. That guarantee that's not what's happening. That would only be if like there's a bunch of freaking law nerds on that jury or something. But yeah. Anyway, so yeah, okay. So I will keep an eye. Do you guys have any other questions? But yeah, that's my thought. So like if they come back soon, because if they could be wrapping up with their lunch pretty quickly, if they come back in half an hour or something, and they're like, yeah, we still can't do it. And then she sends them back again. And then they come back at 3:30 or something and say, we still can't. I think that'll be different than if they don't come back up until the end of the day today. I could see that having two different outcomes as far as whether or not they go on to Monday or not. And then, you know, who knows? Maybe they'll come back with a freaking verdict, guys, right? That's also possible. This is insane. It's not in the jury instructions. It's not in the jury instructions, no. And by the way, when I covered that the other day, feels like a million years ago, I have really specific timestamps. There's like a gazillion timestamps. I timestamped the fuck out of that video with the closing arguments. It's the closing arguments video because the jury instructions are after that. And I timestamped like every single change of topic in the jury instructions. And so if there was anything about a mistrial, that would have a timestamp, and it does not. I think there is an instruction that does say something like that, Kit Smith. I think that's in the general instructions. And in this case, they don't even know. Like, I guess LWOP is on the, I feel like we don't even really know. Like, we've not heard the Commonwealth talk about what the options are, especially if it's obviously one of the other charges, right? Like the second charge or the third charge, and then there's those also included. So it's like, so in this case, it's really anybody's guess, really, to what the sentence may be, unless it's, and like, so with the exception of like the first charge, right? Then I would imagine that's LWOP. Although I could also see them giving her parole, because she is a first-time offender, and I don't know. It's interesting. And second degree, and of course that also varies by the state. But yes, Kit Smith, they do. Oh my God, I just saw the fan move. Did you guys see the fan move? Or was that my computer moving? Did I bump my computer, or did the fan move? I'll leave it up for another minute just in case. I thought maybe the fan moved. And we're live, right? Yeah, we're live. So, but even still, even if it does have that, it doesn't say anything about a mistrial. Right, exactly, Kit Smith's right. Okay, you saw it too. Interesting. I will say the fan bumped a bunch of times today and nothing happened. It was a really crazy bumpy day. Like after they came in first thing in the morning, there were several times where I was like, oh my God, are they coming back? And then they weren't. So maybe it's just one of those situations, but I'll give it another sec. I guess even the only fan is nervous right now. Crazy. So, wow. What do you guys think? Are they going to come back with a verdict, or are they going to come back and say they can't do it again? It could just be, hi, DSN, are you up to speed on what's going on? We just talked the fuck out of it. Happy to see you, my friend. I almost threw up. That's for sure. Okay. Yeah. Do you guys think that they're going to come back with a verdict, or do you think they're going to come back and say they can't do it again? And need to read the Tuey-Rodriguez charge. DSN also, we read the charge too. I don't know if anyone else has done that, but we read the full Tuey-Rodriguez charge too. So, because that's specific to Massachusetts. Like my guess was like, that must be specific to Massachusetts. Why aren't they saying Allen charge? I bet it's specific to Massachusetts. Sure enough, yep, it's specific to Massachusetts. So I'm sure everybody else was like, what's that? But we read it. And the languaging in there, I think, is beneficial to the defense. I mean, technically, it looks like it would be beneficial to anybody, but like in this case, I think it would be beneficial to the defense. Because again, I think that it's 11-1, my guess. Is that there's that one holdout for guilty. So do y'all have any thoughts on what's going to happen next? No, it wasn't DSN. It was just go have lunch and then don't think about it and then try again. Which is interesting, right? Because it's almost like making them take longer. Because remember like what I was saying? I don't know, man. Remember what I was saying about how like if they wait until the end of the day to come back and say that they can't do it, my guess she'll be like, come back on Monday. But if they come back sooner, it'll be a different story. And it's interesting because normally they have lunch at 1 o'clock. It was 12:15 when she said, go out, we're going to go out and bring lunch for you. Take a break. I don't know. It's interesting because then she's like, don't talk about it anymore. Wait until after lunch. I don't know. Do you guys see where I'm going with that? It's interesting. Like if they had waited until 1 o'clock for lunch, it's entirely possible they could have gone back to that deliberation room and come back before 1 o'clock and said, we can't do it. Yeah, Tuey-Rodriguez charge in this case. And we read it. And again, I think it's helpful for the defense. So I hope she reads it. So, yeah, but I'm wondering, so their lunch is usually an hour. I mean, if they did get lunch when she said that, it was like 12:15. then they're probably about done with their lunch at this juncture. So, right, Kitsmits, of course. Right. And honestly, the Tuey-Rodriguez instruction is great. It does give instruction on how to move forward. It really does. It really does. I mean, I think she should have read the instruction, and that's what Yanetti was asking for. But again, that's why I'm wondering if that's like a last resort thing, to where I wonder if like in Massachusetts, it's like once you read that, if they come back again, it is a mistrial and that's it, right? I'm wondering if that's the case, because why would you not read it, right? Like, why would you not read it? You should read it. You should read it. And so that would make sense as to why Yanetti's asked for that. And then Lolly was like, nah, it's too early. Like, why would you not want them to have it read to them? Well, in this case, I think it's because it would be helpful for the defense. I think they would be more likely to come back not guilty after the instruction, honestly. I still can't believe that this is even happening because it's scary, right? Like, what is going on? I know that's insane. I don't understand. It's like, wow, that's just scary. So let me pull up. Oh, did I close out of it? Wait, that's not what I meant to do. Hold on. I meant to do this. Here we go. Aha! So this is the Tuey. Again, we already read it, but I think this is much different than what we just saw from Judge Bev. And this is much better for the defense, I think. And this is specific to Massachusetts. So we're back to the ban. I know. I mean, the thing is like what it really comes down to at this juncture is after hearing from the crash daddies and also the defense forensic expert, the forensic pathologist. I mean, they said what we've all been thinking, which was he was not hit by a car. If he was not hit by a car, she walks on all those charges, right? Like, that's it. There is nothing else. She walks on all of it. He has to be hit by a car for any of that to matter. And that's what's so wild, man. I know. They said exhaustive. Yeah. I know. I agree, DSN. Right. I mean, absolutely. Yeah, absolutely. But then the other thing that was really important that came from the defense forensic pathologist was like that head injury would have killed him right away. Like he would have been down for the count. Like he couldn't have taken steps. Actually, I was going to wait till we reviewed him in a recap, but like that's also why I'm still wondering about that freaking fire hydrant, which was never tested because, that could also, it still could be possible, right? But the thing that matters is we know he was not hit by a car. And that's why this is insane that there's anybody who could be a holdout at all. I don't know. I mean, and think about it too, right? Like if there's a holdout for guilty that believes Lolly, you have to think about that type of person. And it seems like to me, the type of person who would not change their mind, right? Because if they were open to listening to reasoning, they wouldn't be thinking guilty. If they were open to using common sense, critical thinking skills, or logic, they wouldn't be thinking guilty. So that's tough. I don't know how that person got on a jury. That's for fucking sure. And the thing is like, Yeah, I mean, it's just the thing is like it's just there's just no way he got hit by. I think if I understand correctly from the way it came from the crash daddies and like the forensic pathologists, it's like it's not only did he not get hit by Karen's car, it's like he did not get hit by a car. Like that's not what happened to him. That is not the explanation for what happened in any way, shape, or form. So hugs back fender. Yeah, I mean, jury tampering, right? I know. Do they have a Becky Hill situation? Well, I don't know. I guess in this case, it would be someone who's like saying they should say guilty, right? Versus, oh, well, I guess that's what they were inferring with Becky Hill. Anyway, I mean, not that she specifically said that, but you know. Okay, it looks like it's back. I don't know what just happened, but yeah. So I know, right? Absolutely. 100%. So yeah, so I will jump back when there's any motion at all because what happens next will either be a verdict or it'll be we still can't do it. So I'll make sure I'm here for you guys. I mean, unless they just take until the end of the day and don't say anything, but that would be very weird, wouldn't it? Because that would be like assuming they're coming back on Monday. I don't know. I guess it could happen, but it's unlikely. DSN, I don't agree with that because in every other trial, when this actually happens, so a jury actually ending up being hung like for real is rare, but this part is actually not that rare. I've watched a lot of fucking trials. What I think even lawyer said something about this the other day. Like what usually will happen is once they get read the charge, not that they were read the charge yet, but usually when they're read the Allen charge, they will come back with a verdict. And that verdict is just as good as any other verdict. This is actually not all that uncommon for them to say they can't do it. But what's more uncommon is for them to not come back with a verdict afterwards and then for it to be an actual mistrial. That's more uncommon. So yeah, they could ask more questions. That's a good point, Fender. But yeah, the verdict is fine. It will have maybe in public perception, but fuck that, right? But legally speaking, the verdict is just as good as if this never happened. So it'll only be for people that are just like whatever on the internet. So, so yeah. Okay. But guys, y'all are the best. We'll be back soon whenever something else happens. So just keep your eyes peeled and I'm going to roll the outro. See you guys probably soon, hopefully with a not guilty verdict.